as an employer, 3 things that are very important to your anti-harassment program. First, you have to have a written policy. And it doesn't have to be 10 pages long. This is something I can help any employer with, develop a policy. But a policy which specifically states we don't tolerate sexual harassment, and more importantly, lets the employees know who they can come to report sexual harassment. Maybe they can't go to their supervisor. It's not okay to just say, well, tell your supervisor, because it may be the supervisor that's causing a problem. So they have to know that they can come right to top management, to you as the company owner. And if you're the company owner and you're doing it, well, then we have to have a talk. But they should be able to know that they can come right to company management, top management, and report this if they feel uncomfortable going to their supervisor. And then you should also have training, at least with your management level employees. If you have 15 or more employees in your company, you should have at least annual training so that this gets into their minds and that they know that you take it seriously. But it's not enough just to have a policy and a training. The law says if you have the policy and the training, then you have a defense if somebody alleges harassment, a situation occurs, and they bring legal action against you. You have a defense if you've implemented that. But if you have this policy and the training just as boilerplate and a dog and pony show, and you're really not serious about it, and sexual harassment still occurs, you can still be held liable. In the case that I had against the state of New Jersey, the state of New Jersey has this huge policy prohibiting sexual harassment. All sorts of procedures, complaint procedures, investigation procedures. They have annual training online for every employee, and more so for managerial employees. Well, the worst harasser in this particular case, in that unit, scored 100% on his annual training. So how effective is online annual training if the guy's sitting there laughing as he goes through the module and scores 100% and then goes back to his unit, his cubicle, and torments the woman seated next to him? It just is not enough. What is necessary is when an employer becomes aware of a situation, that it steps in and does something. Hopefully it starts with a warning, a serious warning. Look, we do not tolerate that. What was said or what was done is inappropriate. Please make sure it does not happen again. And again, hopefully that resolves the situation. But if it does not, then you as an employer also have to be prepared to take further action, even if it means suspension or termination of a good employee. Because ultimately, that is how you are going to change the culture in your workplace. That is how you are going to get a message through to your workforce that we're not going to tolerate this regardless of who you are. There's nobody in this room that's that important that we're going to allow our company to be sued and to be exposed to these kinds of damages, and perhaps the bad reputation as well amongst customers and the public if something like this would become known. We don't want this for a company. So if you're going to behave like that, we don't want you here. And you've got to make your workforce understand that. In the state of New Jersey case, it was really almost unbelievable that manager after manager simply disregarded this woman's complaints. And after a while, she's like, well, why should I make any more complaints? Because nobody's going to listen to me. Until the point where she had a nervous breakdown, psychological treatment, was in the hospital, all because of the depression and anxiety that this situation created. In the investigation, when they finally started an investigation, the investigator literally emailed some of his interview questions to some of the witnesses and let the witness fill them out and email them back. That's not how you do an investigation. that doesn't show that you're very serious about getting to the bottom of the situation. And it was just a follow the steps, get it done so we could say we did the investigation, create our report, and be done with it. And that's all that they did. That type of behavior tells your workforce, again, we're not serious about it, we don't care, we just have this policy here because we're supposed to, and it's not really going to change anything in your workplace. You also have to be careful to prohibit retaliation. Again, you may have the person who's doing the sexual harassing may be a popular guy in the workforce, maybe a good performer. And this kind of allegation or accusation is not going to sit well with him or his friends. It's not a good mark against their career, and they may start doing things to retaliate, ostracize. They may, I've had some situations where they undermined the other person's work, where everybody needs to do something to get the project done, and they would deliberately do things or not do things that this person needed to get done, and therefore would make her job very difficult and impact her performance. This kind of retaliation cannot be permitted either, even if the situation doesn't sound that serious. It doesn't sound like there's been that many remarks or anything that's risen to really the level of a hostile work environment yet. If an employee makes a good faith complaint, they cannot be retaliated against it, even if you don't think that that behavior really was that objectionable. Okay, so to answer your question in terms of what employees can do and how they can help prove sexual harassment occurring in the workplace, there are several steps that they can take. First of all, an employee who is confronted with sexual harassment should hopefully be able to tell the harasser that the conduct is unwelcome. That is always the first step. In some cases, people just say dumb things. And if they are made aware of the fact that their conduct was inappropriate or unwelcome to a particular person, that may be all is needed to correct the situation, and then it may never happen again. Yes, Michelle?
Does that have to be written, should that be written up, that you spoke to that person at that point, put that in their employee file?
No, for the employee file, well, for the employee, this is talking about an initial conversation where a person has experienced sexual harassment. Instead of being quiet, instead of just hoping that the situation goes away and that they won't do it again, it is very appropriate for them to simply say, I did not appreciate that. That conduct was unwelcome. And again, the reason for that is people say dumb things unintentionally, and if they become aware that this person is sensitive, they may then avoid it, and you as the employer don't have a problem. But it's when the person is intentional, when the person doesn't care about another person's feelings, and the conduct continues, that you as the employer want to be able to step in and nip it in the bud. As an employee, now hopefully your company has the policy that we've been talking about in the training, so that you're aware if the situation arises, well, this is who I should report it to. And you should. And you should report it in writing. Too often employees don't, again, for whatever feelings of fear of retaliation or whatever, but it is important if you're an employee and you're experiencing that, to just a simple note that says, I have a situation here that I'd like you to take care of for me. This person made a remark or behaved a certain way, and I feel uncomfortable and I would like it addressed. Very simple. Then also as an employee, you should keep a journal of the type of behavior that is going on. And in terms of proof, this is what's going to help an attorney later on. If the employer does not address the situation, this is what will help an attorney address the situation. Because rather than coming into my office, months, years after this conduct has been going on, if you've been keeping a journal and you write down the dates that certain remarks were said and who was present and who said what, And if you write down when you went to speak to your boss, just like a little diary at home, when you walk into that, and it's a rare case that I've had a client walk into me with this kind of documentation, but to have somebody walk into me with a journal where they have documented dates, times, places, persons, witnesses, all of that information, then it is so much easier to be able to document, to be able to make that proof in a legal situation. Because then I know who I need to talk to. I know witnesses I can potentially call who will be hopefully favorable witnesses, or even if they're not, people that I may need to depose as part of the legal process. It is so much more valuable information by keeping this journal as you're going along.
Scott,